Welcome back to Carolina Journal Radio. I'm Mitch Kokai. The latest U.S. Supreme Court term once again featured some major rulings, including rulings with direct impacts for North Carolina election maps and the State Revenue Department's powers. Joining us with insight on these cases and other important developments at the nation's highest court is Ilya Shapiro. He is director of the Robert A. Levy Center for Constitutional Studies at the libertarian Cato Institute. Welcome back to the program.
Good to be back. Missed you last year, but enjoying your new digs.
Yeah. So you're one of the first interviewees in this new room now that we've changed our offices. One of the big rulings nationally, and of course North Carolina implications as well, had to deal with partisan gerrymandering. What did you think of that 5-4 ruling?
Right. So the court said that we're going to stay out. Federal courts are going to stay out of fights over use of partisan reasons to draw state district lines. That if you have a problem with here in North Carolina, Republicans, in Maryland, the companion state, it was Democrats giving the shaft to the opposing party. Your remedy is under the state constitution or politically vote the guys out, amend the state constitution, things like that. They are not to go into federal court. I think that's right. I don't think the Constitution says that you can use a little bit of political gamesmanship, but not too much. That's not really a constitutional line to be drawn, and so the court's correct to find this issue what they call non-justiciable.
Is it fairly clear that this shuts the door?
Absolutely.
Okay, very good. And might not open up again with future liberal justices, or?
Well, they would have to overturn this particular decision, so not anytime soon.
Another big case with North Carolina implications, maybe not on the national level, but certainly for folks here, is a case dealing with our state revenue department hoping to tax a trust. And the Supreme Court said, no, you can't do it.
Right. This was a trust set up in New York State, but certain beneficiaries or potential beneficiaries were resident in North Carolina. They hadn't received the money yet, or they had received some, but no guarantee that they'll get any in the future. But the Department of Revenue still wanted to tax this out-of-state trust. And the court said, no, you can't do that. You can tax the income coming in for the beneficiaries that live here because that's part of their income tax. But some out-of-state trust that it's unclear whether they're going to be sending money to beneficiaries now or in future, that's not enough of a basis for taxing that institution.
Sounds like the type of ruling you think would be the right one to make.
I think that's right. That respects federalism. You can't have states just willy-nilly taxing out-of-state institutions.
Among the other big rulings coming from the Supreme Court was one that had to deal with the citizenship question on the U.S. Census. Tell us about that one.
Well, this is a moving target. As we're recording this, President Trump has been tweeting and could sign an executive order any minute now to purport to add the citizenship question to the census by executive order. The court ruled here, this is the Commerce Department wanted to add to the decennial census coming up in 2020, the question about, are you a citizen, how many citizens in your household, not asking about whether you're in the country legally or illegally. I was a green card holder, non-citizen, perfectly legal in the country for a while, and we've had this citizenship question, I think almost every census or long-form census, for a long time. We didn't the last time around, not in 2010. So it's some controversy. There's a debate among social scientists about whether this would decrease the response rate because some people might be fearful, even if they're in the country legally, they might be fearful of answering the question to see if that would decrease their benefits or they'd be prosecuted or who knows what. And the court basically said that maybe the executive has the power to add this type of question, but they need to provide an adequate reason. And here, Secretary Wilbur Ross's reason that it would be to help the Justice Department enforce voting rights doesn't pass the smell test. And now we're sort of in overtime, seeing whether the courts will indeed allow the addition of a question for the right reasons or not. There's a practical wrinkle because the government's lawyers represented in court that June 30th was the drop-dead deadline for getting the census printed, but maybe not because most of it's online. That's still in active litigation.
Taking the politics of the moment and setting that aside, from your perspective, what do you think about the court's ruling about the fact that the government may have the power to do this, but we think the reason you used was pretextual, so we're going to strike it down?
Well, I mean, this was a failure of lawyering on the front end by the Commerce Department lawyers, not by the Solicitor General, not by the arguments made in the Supreme Court. It was too late by that point. Under the census legislation, the discretion given to the executive is pretty broad, but you can't act in an arbitrary manner. So as long as, half-baked lawyer should have been able to give Secretary Ross dozens of valid reasons, uncontroversial, even saying, we want to do it for political purposes. Maybe that's okay, but just coming up with something that doesn't pass the smell test, or contrived is the word that Chief Justice Roberts used, that's not enough. I think that's probably right, but in general, I do think that this type of question can be included if you cross all the T's and dot all the I's. It's kind of like Travel Ban 1.0, the Steve Miller special that wasn't lawyered up properly, versus later on down the line once they got the adults in the room to do it all right.
There are a lot of other interesting rulings, but you also wanted to point out one that has to do with the administrative state.
There's a couple. I mean, this is a theme that's growing in our politics, in our jurisprudence, and in academic and political discourse about the growth of the administrative state, meaning executive agencies, whether it's the EPA or the Department of Labor, all of these executive agencies that effectively rule our lives. Congress doesn't pass much legislation at all anymore, so it's ruled by regulation from these agencies. And there's pushback about judges deferring too much to the agencies in their determination. So there's an important ruling in a case called Kisor, K-I-S-O-R, that was a challenge, a run-of-the-mill case involving veterans benefits, where the Veterans Affairs Administration just changed its interpretation of a particular word in a previous regulation to deny benefits to this veteran. And how much should courts defer to that just change of interpretation without more? The court didn't overturn the deference doctrine called Auer, A-U-E-R, but the joke is they reduced the Auer deference to minute deference. That is, the courts need to scrutinize whether the agency really is applying expertise, scientific, economic, whatever, and whether there actually is ambiguity in that regulation, that it can be reinterpreted. Just willy-nilly policy change, you can do that, but you have to go through full official rulemaking, not just a change of mind to go into court and do that. So watch this space. If the lower courts in future are still deferring to the agencies too much, if the agencies are still all powerful and doing whatever they want, 5-10 years down the road, you could see a further challenge, and maybe then the court will be more receptive to overturning the doctrine altogether. A different side of the same coin is if Congress is giving agencies too much power, by which I mean Congress is the legislative branch. One thing it can't legislate, however, is giving away its own power to whether it be the executive branch or you and me. Here in this case, it involves the federal sex offender registry, where Congress could not come up with a compromise that they could pass in a law about what to do retroactively. Those convicted sex offenders that had served their time before this new Registry Act passed in the mid-2000s. So they basically told the Attorney General, you get to write all the rules about this. And we've had, I think, 4 or 5 attorneys general since Alberto Gonzales in the mid-Bush years, and they've changed the rules. They've tweaked them, they've rewritten them. That is not the rule of law. That is, by definition, the rule of man. And it seems like a problematic, what lawyers would call, violation of the non-delegation principle. Now, in American history, only 2 times has an act of Congress been struck down as delegating legislative power to the executive. Both of those times were in the year 1935. Here, Justice Kavanaugh was not participating because this was argued that first week when he was still answering questions in the Senate. The court ruled 5-3 to uphold this particular delegation, but the 5th vote was provided by Justice Alito, who indicated that in some future case, when there is a majority willing to reconsider what we're doing here, he'd be open to that. So that, I think, is an invitation for future challenges to very broad delegations that Congress makes to the administrative agencies.
Looking beyond specific cases, you've already mentioned him, the newest Justice, Brett Kavanaugh. What impact has he had?
Well, every time there's a new justice, it makes for a new court. There's a different dynamic. Even if you're replacing, even if Gorsuch for Scalia, very similar, but still, their interpersonal relationships, voting patterns, influence is different. Kavanaugh, we're still trying to figure him out. surprisingly, he was the justice most often in the majority this term. We talk about John Roberts truly being the Roberts court now with Kennedy gone. Roberts was second to Kavanaugh in terms of being in the majority. Now, that might settle down, and this was an unusual term in many ways, not too many blockbusters, the census and gerrymandering aside. But interestingly, Kavanaugh agreed as much with Justice Kagan and Justice Breyer as with Justice Gorsuch, his fellow Trump nominee, his fellow Republican president nominee, his fellow co-clerk. They clerked for Justice Kennedy together. So watch this space. It's a very fluid court that it'll take a while to really settle in, but certainly not the radical right term that some were fearing or expecting, based now with 5 so-called conservative Republican appointees on the court.
You mentioned Roberts. Now with this new court, what is the Chief Justice's role? Some people thought, well, perhaps he's now going to become the swing vote that Anthony Kennedy was. Have we seen that?
Well, he's not a swing in the sense that he's truly a moderate who could go either way and he agonizes and hand wrings. It's more that he views himself as the protector of the institutional integrity and reputation of the court, trying to forge compromises, being very restrained and minimalist, deciding not to decide as much as possible, trying to keep the court out of political battles. I'll let you be the judge how successful he's been at that in the nearly 15 years he's been chief now. On the very last day, you saw this kind of action. Those two biggest cases, or highest profile cases, gerrymandering and the census. In both, he was the key vote. In gerrymandering, he wrote the opinion slamming the door on partisan challenges to partisan gerrymandering. In the census case, he provided the 5th vote to not allow, at least for now, again, ongoing litigation, this question to be added, so conservatives were mad at him. But in doing these together, he was trying to forge a middle path without being squishy or moving left. I don't think anyone can, who's being applying good analysis, is saying that he's now a liberal. John Roberts is a conservative, but very much he's a minimalist, incrementalist, cares about the institution more than he cares about originalism or textualism or kind of coherent interpretive theories to apply.
Last question. Trends that you have seen either coming to the fore this year or that you're going to be looking for in the next term?
Well, it's what we've been talking about, these voting patterns, agreement rates. I'm looking to see, Justice Kagan and Justice Breyer with John Roberts and possibly Kavanaugh trying to forge kind of a center pragmatic course, not to move too far or too fast in any direction. How will that play out? Justice Kavanaugh, as he settles in, as we get further from his bruising confirmation battle, will he be closer to Gorsuch and Thomas? Will he be closer to Roberts? Be his own thing? The 5-4 decisions, this term there were 20 of them, of the 67 cases. 8 of those 20 were the conservative 5 over the liberal 4, so-called. Another 8 were the 4 liberals plus 1 of the conservatives. 4 of those were Justice Gorsuch in criminal procedure cases. Not surprising, by the way. This is the same way Scalia was in these protections for criminal defendants. And then 4 were kind of heterodox. We'll see how those alignments continue. Next term is going to be a much higher profile. We already have DACA, whether President Trump can rescind the Executive Dream Act, as it were. I think I'm in favor of the Dream Act, giving status to people who were brought here illegally as children, but I don't think the executive has the power to do it alone. And certainly if the executive if it's just executive discretion, then a future executive should be able to withdraw that, but obviously very contentious. Whether Title VII of the Civil Rights Act, prohibition on discrimination based on sex in employment, whether that applies to sexual orientation and gender identity. A textualist case, what do the words of the statute mean? But it's going to be blown up as to, should we be able to discriminate on the basis of sexual orientation and gender identity, which is a question properly for Congress. Again, but that's going to be a big deal. A school choice case out of Montana. So there have been favorable rulings in the last 15 years allowing school choice programs, tax credits, vouchers to blossom across the country. But at the certain state level, they have these things called Blaine amendments, which prohibit public funds going to religious causes. They were the product of anti-Catholic bigotry in the late 1800s. Vestige of that, and the Montana Supreme Court struck down its state's school choice program on that basis. The U.S. Supreme Court will now take up whether Blaine amendments themselves violate equal protection and discriminate against religious believers. So those are probably the three biggest cases. There's going to be more. Obamacare is on the docket in various ways, technical things, not constitutional attacks on the individual mandate or anything like this, but that's going to draw a lot of attention.